Mr. Jolly, do not overtalk me, because it will never work. Court does call the case of the People's State of Michigan versus Cody Jolly. I think it doesn't matter. State your name, sir. All right. Date and time set for a preliminary examination. Are people ready to proceed?
That is correct, Your Honor. People are ready to proceed. A few things at the outset. I would ask defendant be reminded of his absolute right to an attorney.
Yes, I will get there.
Okay. And I also asked Ms. Gaines to be present if Your Honor would be willing to appoint standby counsel if the defendant does not want to be assigned an attorney. I also am going to make an offer to Mr. Jolly to plead to an added count 3 and 4 of aggravated assault under MCL 750.81A. That is a 1 year and or $1,000 misdemeanor offense. In exchange, I would dismiss counts 1 and 2, which are criminal sexual conduct in the 4th degree, which are 2-year misdemeanors and are $500. And would require registration on the sex offender registry. This is the first opportunity I've had to speak with Mr. Jolly, so I would ask that he decide if he wants to move forward with the exam or if he wants to take that offer.
What's the offer?
The offer is to plead to an added count 3 and 4 of aggravated assault, which is a 1 year misdemeanor and or $1,000 fine.
But what's the suggestion? I mean, that's not a plea. I understand that you're changing the charges, but there's no plea. What's the plea?
That is the plea offer. And then I would dismiss count 1 and 2, which currently charged with, which is criminal sexual conduct in the 4th degree. That is the plea offer, sir.
So what's the jail time? A year in jail is what you're offering?
The maximum penalty for that is a year in jail.
There is no plea. So you just want me to
hold it, Mr. Jolly, Mr. Jolly. No, you're trying to argue. Mr. Jolly, they've offered you, that's an offer. Okay. But hold on before you just start making these rash decisions, because that's how you're where you are right now. Okay. So first thing I want to advise you is today's the time set for your preliminary examination, and you've elected to represent yourself. I will tell you that having watched you through the various proceedings, I have some concerns about you representing yourself, and but you're absolutely have a right to do so. But I need you to understand that you're charged with 2 felony offenses or high court misdemeanor offenses of criminal sexual conduct in the 4th degree. You understand that, sir? You understand that they're punishable by up to 2 years incarceration, $500 fine plus court costs, mandatory HIV STD testing, and DNA would be, well, DNA was taken upon your arrest. You understand that, sir? All right. Now, you understand that there are grave dangers that can occur by you proceeding on your own without counsel. All right. You understand also that I'm not here to play favorites to either side. And so I will not be in a position where I can assist you in any way. I will hold you to the exact same standards regarding court rule, presentation of evidence, and everything along those lines that I would hold the people to. You understand that? You understand that if you wish at any point to be represented by counsel to help assist you in any way, that the court would make sure that counsel would be provided to you.
I do understand.
All right. Now, Mr. Jolly, and I'm going to say this, not necessarily part of the admonitions, I'm very concerned that you don't know what the proceeding that you're in right now is.
The preliminary examination, when you told me initially, you told me that when preliminary examination And he told me that the two of us.
That what?
The two alleged victims would be here on today's.
I didn't say that.
Okay, so they don't have to be here today?
I did not say that.
But they're supposed to be here.
Do you know what proceeding you're in? Okay, let me ask you this. If the people are successful at a preliminary examination, what do you believe happened?
To ask for a question about a preliminary, and I'm also asking for a jury trial today.
Okay, but
Then I would.
Mr. Jolly. If the people meet the burden, what do you think happens?
Pardon, what?
If they meet their burden at a preliminary examination, what do you think happens at that point?
We'd have to go on to either preliminary or trial, depending on what your decision.
You understand that you're at the preliminary now.
He said it was examination, but if this is preliminary, we can move on to trial. I'm okay with that. I expected there to be two witnesses here today, two alleged victims here today. That's what I expected. I think that's right according to the way it should have been. I thought that was right. I am asking where the two witnesses are, two alleged victims. Yeah.
Mr. Jolly, I understand you want to get to a certain point. I have concerns about whether you understand what you're doing.
Yes, I do.
What do you believe you're doing?
Trying to get to trial. Proven innocent.
You understand you don't have to prove your innocence.
I understand that you would have to prove it. So the courts, whoever the state would have to prove me being guilty beyond a reasonable doubt. And
Mr. Jolly, have you?
We have where are the two alleged victims that were supposed to be here today? Question for the court.
Sir, I'm not sure how the people are going to proceed in their case. Okay? So I'm not going to answer your question because I don't have the answer to that. Do you understand the offer that the people have made to you?
I do.
Pardon?
I do understand the offer.
What do you understand the offer is being? Mr. Jolly, do not overtalk me, because it will never work. Are we clear? Mr. Jolly, are we clear? Are we clear? Do you understand the offer that the people have made? What do you understand that offer to be?
They said they're dropping from the CSC they're requiring, but they're dropping them to assault. So there's still two charges and up to a year.
But two misdemeanors.
Correct.
That may not have any incarceration with it.
Problem is I didn't do anything. So it's really hard to plead anything. So.
Let me ask you this, Mr. John. They don't have to represent you. All right. But would you at least like to talk to an attorney about what that offer means and what risks that you're potentially taking in just outright saying no, as opposed to whatever? Would you at least like to talk to an attorney about that?
I'm just going to move on. To be honest, I'm just going to move on.
You're not answering my question. Would you at least like to talk to an attorney? I'm not trying to have you bind to anything, but just to have somebody explain to you what it means. Would you at least like to talk to somebody? I'm not even saying.
Honestly, okay. I'm just upset.
What?
I'm upset with the entire court process.
Okay, you can be upset with the entire court process. I just want to make sure you understand everything that you're doing and to provide you an opportunity to talk with legal counsel to explain this and that. That doesn't take it out of being your decision.
Right.
But at least you can talk to somebody and get more information in making that decision.
And I have no need for it. If you're required, I'll talk.
I'm not requiring you, Mr. Jolly, quit playing the victim. I'm not requiring you to do anything. I'm offering you an opportunity to talk with a lawyer so that at least everything can be explained to you before you make a decision. Because my concern is that you're making a rash decision heading forward, not quite understanding entirely what you're doing. You're trying to get someplace, and I don't think you know where you really want to get to.
Well, thank you. Trial. I thought there was a preliminary to this. There's not.
There's a preliminary today. You understand that?
I would ask for a jury trial.
Okay, that's it. I'm done. I explained to you at the last proceeding when a jury is going to happen and when these proceedings are going to happen. Because at this point, do not overtalk me again. I'm done trying to deal with you. I thought that there was at least some rationality to your thought process and what you're trying to do. I am very concerned about that. I'm very concerned about your competency to be able to stand trial and to head forward. Because you're not tracking what I'm telling you. You don't have to agree with me, but you're not even tracking what I'm telling you. You're off on something else. I thought the last time we were here that was some sort of aberration and not something that is fit you. And I explained to you that we were going to this proceeding, and I don't think you know what proceeding you're in. And you keep saying at times the same thing to me, although I explained to you process-wise how this happens. And so what I'm going to do on my own motion, for good or for bad, but I have to make sure and be sure that this is going to happen. And in light of the activities also of the bond violations, I'm going to refer to dependency on my own motion for competency in this case.
Can I just go talk with the attorney?
And Ms. Willingbrink, if you would be so kind for the court to prepare an order to that respect. I'll set a competency hearing for, give me 60 if we can get it done. We'll have to turn it out.
June 27th at 9 a.m.
June 27th, 2024, 9 a.m. is when I'll set his competency hearing, and I'll look forward to the order.
Question.
Now, do you want, you indicated you want to talk with an attorney.
If you would like me to talk to an attorney instead, that's okay, yeah.
No, it's not instead. If you want to talk with an attorney, Mr. Jolly, I will make sure that that happens. Do you want to talk to an attorney?
You put me through competency then.
No, I'm not putting you through anything. Do you want to talk to an attorney? Yes or no?
Yes, sure, I'll talk with him. I don't.
Fine. Ms. Gaines, he does not wish to have appointment. Would you assist the court in speaking with Mr. Jolly? I've set it for competency, but maybe he has asked for some legal advice. Can you assist the court in that way, Ms. Gaines?
Yes, sir.
Thank you. So we'll do that. I'll have his bond continue. You can take the defendant back, and Ms. Gaines will be back there to talk to you momentarily, sir.
One more question, just the jury trials.
That's the problem. You don't even understand where you are in the, no, you don't. No, you don't. I'm done. Bye.
Good morning, Assistant Public Defender Lauren on behalf of Ms. Haywood. Please.
Unique Haywood.
Your Honor, we are here today for a pretrial. There also is a bond violation in
Oh,
the
yeah,
file.
there is. Why don't we deal with that first?
Sure. So, as you can see in the bond violation report, Ms. Haywood, for the first chunk of positive tests, did do an ETG test, which did come back negative for alcohol. She has, and that ETG should cover the period for those positive tests. Since then, she did have another positive test. I think the last one.
Which ones are you talking about the ETG covered?
She took the ETG on the 15th
Of March,
of March.
right? But that doesn't cover, that might cover the 12th, the 13th, and you're saying the 14th,
Right,
okay?
right. Because the ETGs go back 72 hours from when she took them.
Yeah, I know how they work. But go ahead.
So she had another positive test, as the court can see. She was going to get another ETG done yesterday. However, she was at work and was unable to do so. I've spoken with Agent Mormon about it, and we haven't really come to a conclusion of what she thinks is triggering the positive test.
Oh, it's certainly not brushing your teeth.
No. She initially thought it was brushing her teeth. She now thinks it was a nicotine vape. That she was instructed to not blow 30 minutes before. She's been waiting 45 minutes and she hasn't had a positive test since changing that. So what I'm asking.
Why aren't I getting retest?
No. The reason why I did the retest the first couple of days was because I wasn't notified that the machine will actually tell me to retest. I thought that there was something that Mr. Mormon was going to have to reset, like off site. So that is my fault and my irresponsibility for that.
So I'd ask Judge if she could do it
Well,
ETG
hold on,
today.
hold on. On the 16th, my problem with an ETG today is it doesn't tell me anything about the 16th.
Right, because of the 72 hours.
And so what I have before me right now is a positive test and no explanation for it.
Well, I suppose our explanation would be the vape issue. I mean, she maintains that she has not drank. She has this vape. She started using the vape when she was told at arraignment not to drink and not to consume marijuana.
Even if the vape has alcohol in it, which I don't think it would, but even if it does, she can't inhale or do anything with alcohol.
Yeah, I don't know why the vape would trigger the positive test. She's had continued positive at very small amounts. So that's our only explanation. I mean, she, again.
So here's the problem with that. The problem with that, even if you're talking a half an hour range, look at the very bottom of the report on the 16th. She submits a positive test at a 0.2, correct? There is then almost 20 minutes later, 18 minutes to be exact, there is a positive test. Again.
I don't have an explanation for it, Judge. I mean, if she was drinking, frankly, I don't know if we'd see that sharp reduction.
That's not a sharp reduction. That's a reduction.
I mean, going from 0.026 to 0.019 in 18 minutes, I don't know if if it was alcohol, we
Within
would
the
see
margin of error? Really, counsel?
I mean, she has consistently maintained that she has not drank alcohol. When she did have a positive test, she did an ETG and it was negative. So I think that explains that there's something else going on that she's consuming that we aren't aware of, that is triggering these positive tests.
Then you need to bring me something that says a vape's gonna do it. Because otherwise, what I have in front of me now, that she has a positive test. And then it's positive on the retest.
Yeah, no, I mean,
And moreover, if it's indeed true, she was instructed not to take the vape prior to testing.
yeah, she has been waiting for a longer period since the positive test, and she hasn't had one since making that change. Again, we don't know. I've had many conversations with Miss Haywood about if it was her toothpaste. I just think that, you know, she
It's that if she wants to go with it being her toothpaste, then
no, we've come to realize that we think it's the vape because since she's waited longer, she hasn't had any positive tests.
where's the vape?
The vape's in my car at the moment.
It's in the car? All right. Then you're gonna need to get some information on this vape, but right now she's got a warrant out for arrest. She's here on an OWI 2. And I've got positive tests coming back. You've given me somewhat of an explanation for the other positive test, but I don't have an explanation for this one. Doesn't work that way. So is there somebody that can go out and get it?
She's here with her family. Her father can go get it.
Come go get it. It's in my purse. The kilo in the car. It's in my purse. It's in the car.
Because right now, like I said, she has a warrant for arrest. So she's going to have to go into custody until we can figure this out.
They briefed me, but he told me that they can call for an alteration in my results. That's exactly the reason why they told me to wait at least 30 minutes prior to taking my test. So during my debriefing, when they were giving me my sober link, they did tell me that the vape is capable of causing an alteration in my results. And that's why they said that they recommend to wait at least 30 minutes prior to taking the test. And the vape is the only thing that's altered in my normal routine. I never thought that it was any type of toothpaste or anything like that, which I told Mr. Mormon as well.
The report indicates you said something about it being toothpaste.
Mormon, he asked me the same thing, and I told him that I've always told him that I believe that it was my vape because that's the only thing that's altered in my daily license being released. And they also told me that the vape is the only thing that would alter it. But they told me that I had at least 30 minutes, and I had been waiting longer than that. And now that I no longer even use it, it's fine.
I think that explains the positive tests, frankly. I mean, with the first test positive,
She was again asked if it was the vape causing the positive test. She asked if it was the vape. She was then advised that it's her responsibility to check all products that she's using to see if they contain alcohol.
yeah.
And that's the absolute truth. That's the absolute part of the program.
I mean, I don't
It's
know.
her responsibility.
Right. And I think she knows that. We've had conversations about that. I also don't know if the vape, even if it doesn't contain alcohol, does something sober like device that positive test.
Excuse me?
I mean, maybe there's something in the smoke that malfunctions the sober link or something. I mean, I just don't know how
Oh,
she.
you want to go with that argument?
I don't know enough about the sober links, frankly, but I mean, I just don't understand. She has a positive test. She took the ETG. The ETG was negative. but we're still having the same issue. And as she said, the only thing that we can think of is this vape.
We'll wait for the vape, let you do your research, convince me that she should be released because right now she has a warrant. I won't send her back for processing at this point. Let's put her over in the jury box, get that in there, and then you bring me something, counsel. Court does recall the case of People versus Unique Haywood.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Haywood. Ms. Haywood, please state your name for the record.
Unique Haywood.
Is there anything else you want to say regarding this bond violations?
Your Honor, I did, thank you for the opportunity to speak with my client. She, at this time, does not admit to consuming alcohol. We did, off the record, speak about the possibility of alcohol from a vape. She wants the court to know she takes full responsibility for using a vape. She reiterated to me she didn't know that it consumed alcohol. She does take responsibility for.
Okay. Can I just, I'll let you go on, but can you just stop right there for a moment? Because there's a number of different problems with this whole argument. Some of which have to do with sort of the global picture of things. With the number of people that vape, I would be seeing this all of the time if it were that vape. That's the first thing. Second thing is, and I certainly will let you continue, but one of the things that's bothering me is the issue isn't necessarily drinking. She cannot consume any product or in any way consume or ingest any alcohol. Those are the rules of the program. And I know it's explained to you. It's explained to you in excruciating detail. She is also, upon a positive test, for whatever the reason, is supposed to retest. She did not retest. She's not following any of the rules of the program. She did not retest after her initial one on the 12th, the one on the 13th, she didn't retest. On the 14th, she didn't retest. On the 16th, she didn't retest. Oddly, then on the 16th, there's a positive test. There are actually two. She does retest. She didn't retest immediately, but she retested and then contacted community corrections. She's the one, according to this, that brings up the vape. According to what was said to me before, that they were then supposed to wait, say, a half an hour or so before she tested if that was it, but they did remind her that she's responsible. She then, 45 minutes after that phone call, submits another test. It comes back positive again. So I'm having a little bit of a difficulty believing that that's it. I also will say, and again, I'll let you continue on, that had it been the vape, she received the unit on March 9th. Which means, and she did a compliant test on March 9th. That means then on March 10th, March 11th, I would have had positive tests. I don't. I don't have, unless somebody's just vapes occasionally.
Hold on. The last 2 points I wanted to make, Your Honor, she does take responsibility for not retesting. She says she should have been more diligent at looking at the device after she tested. As for your last point about when she got the device, when she started testing positive, she normally does not vape. She started using the vape after she got the device. So that's why when she says she hasn't, that's the only thing that she thinks it is because that's the only thing she's changed out of her normal routine from when she got the device to now. And that's all I wanted to say.
Then I still would have had a positive test on 10 or 11, 10, the 10th and the 11th, if that were indeed the case.
When did you start vaping? I purchased my vape on the 12th.
Yeah, of course.
I did. When did you start using it? I started using it, I used it on the 12th that morning. Okay.
Anything else?
I mean, I would reiterate my request, Your Honor, to have her do an ETG today, switch her to a scram tether and adjourn this out to see if she continues having tests, in order for her not to use any nicotine or vaping products.
Does she want a hearing on this, or is she admitting to the violation? I mean, I'm not sure what you're doing here. I mean, if she does neither, I'm going to set it for a hearing. So, I mean, she doesn't have to say. But
Your Honor, let's set it for a hearing, please.
set this for a bond violation hearing. My normal date would be the 3rd, but since she may likely be in custody, I'll set this for March 27th, 2024. That's a special time at 9 a.m. for the bond violation hearing. What is the alleged BAC in this case? I see that there's a prior.
Yes, Your Honor. In this case, the alleged BAC is a 0.192, and there was a crash, a single motor vehicle crash.
I didn't do the arraignment, so how long?
She was on probation for operating while visually impaired out of the 34th district. That conviction entered on August 3rd of 2023. The offense date on this is January 22nd, 2024.
Got it. All right, I'll set a bond hearing for that March 27, 2024 date at 9 a.m. Defendant's bond is reset. Your bond is going to be $25,000. I'll give a 10% privilege on that. However, prior to any release, if she posts that bond, she's to be placed on a scram tether prior to her release. Defendant is remanded.
Thank you.
Is Ms. Haywood here?
She went to go download the scram.
Okay, they had indicated to me, or at least the information I got back is, we won't get anything today.
We will get essentially an indication if there's something that needs to be reviewed by the scram expert.
Got it.
What we will not get is confirmation of an alcohol consumption event.
Because they have to, right?
Correct. But there will be an indication if something needs to be reviewed as a potential alcohol consumption event.
Okay, let's do this then. What I'm inclined to do is adjourn this to the 10th. The people don't need to have their witnesses available. And that way we can monitor it and then make a decision as to whether or not you need to proceed forth with the hearing. Does that make sense?
That works.
Okay. So I'll adjourn it to April 10th at 1.
It's actually 9.
At 9? Okay, April. Right, it'll likely go to the afternoon, but I'll set it for April 10th, 2024 at 9. But we'll likely set that in the afternoon.
Okay.
But I'll say for the hearing in pretrial.
And she can go, we're not gonna hold it.
Correct. She can go, her bond will continue. Because she posted and it's on the scram, so. All right.